Hi, my name is Adam Bergman, and I'm a partner with the IRA Financial Group, president of the IRA Financial Trust Company. Today I want to discuss the legal foundation behind the checkbook control of the self-directed IRA LLC structure. Essentially, 1996 Swanson case was the case that really put the checkbook control structure on the map. Before that, most people were using the custodian to make the investment. So you'd have the custodian up here, care of your IRA, buying the real estate, for example, or making the private business investment, and the title of the investment would be, for example, IRA Financial Trust Company, custodian for the benefit of the Adam Bergman IRA. So this whole Swanson case basically involved an entity. In the Swanson case, it was a DISC, but the entity is not so important. The whole importance of Swanson is it legitimized the use of a special purpose entity, newly established, wholly owned by an IRA, managed by the IRA holder in order to make an investment. So this was the first case that really discussed and really put in the spotlight whether you can use a special purpose vehicle wholly owned by the IRA, managed by the IRA holder to make the investment. And the tax court said, yes, it could be done. It's not so important that the entity was used. What's important is ultimately what the money was used for once it reached the LLC. And the tax court basically said that, yes, you can own, your IRA can own a newly established or a wholly owned entity and be managed by the IRA holder without triggering the prohibited transaction rules under 4975. In fact, the tax court slapped sanctions on the IRS. They felt that their argument was not something that was legitimate based off where the court was, and they slapped sanctions on them for their position and maintaining that same position. So that really set the path for the checkbook control of IRA LLC for being the most popular investment vehicle for making alternative asset investments with retirement accounts. The IRS later actually, what I'd say, kind of codified the decision in Swanson in a field service advisory opinion 2001-28011, which basically just reflected the same facts in Swanson and basically advised their field agent saying, hey, this is now the position. And that was really it until tax court memo case 2013-245 Ellis v. Commissioner, which for some reason the IRS seemed to try to argue that the setup of a corporation wholly owned by an IRA and then managed by the IRA to make an investment was in itself prohibited. And of course, the court said, no, that is allowed. What you need to look at, and what the court looked at in Ellis, was what was the money used for. In the case of Ellis, it ended up being a clear prohibited transaction. The IRA was invested in a business. The IRA owner was involved. They didn't follow the ROBS, the rollover business startup framework, properly. They used a IRA instead of a 401k, and it was clearly a prohibited transaction. But that's really not the significance of the case. The significance is really the first case that talked about an IRA owning, in this case was an entity, again, wholly owned by the IRA, managed by the IRA owner, and clearly said that is allowed. That's not a prohibited transaction. That will not trigger the prohibited transaction rules. You need to look at what the investment in the entity is doing, not in itself the framework of a wholly owned entity, an IRA, and managed by the IRA holder. That, again, is perfectly allowed. And really, that's what people are doing. They're not looking to do anything against the prohibited transaction rules or use the LLC as a way to navigate around the prohibited transaction rules. All it's being used for is a special purpose vehicle to give people limited liability protection, more efficiency, a little bit more control over their asset, save on custodian fees. And that's been the case. And that's what real estate investors specifically are using over the last 15 or so years, is the special purpose LLC, the self-directed IRA LLC, also known as checkbook control, to make investments. The Swanson case, the field service advisory, the TC tax court memo Ellis case is, again, three cases that people rely on for the position. I've spoken to the IRS about this numerous times over the last 5 or so years. And again, they're not so concerned about the actual use of the LLC. And I've seen this in audits of clients. It's more what is in fact the IRA money is being used for. And that's really what the case law says. Don't just look at the use of the LLC and the fact that it's owned by an IRA and managed by the IRA holder. Look what the LLC is investing in. If the LLC is investing and it's doing a prohibited transaction, that's going to trigger the prohibited transaction rules. Whether there's an LLC there or not, it's irrelevant. You need to look what the money is being used for. The fact that you're using an LLC as the vehicle is irrelevant, and that's what we now know from tax court cases, and that has become the IRS's position, whether it's the field service advisory or IRS agents. That is what their position is, to look at the ultimate investment, not the structure. Adam Bergman, IRA Financial. Hope you found this video helpful. If you have questions on the checkbook control, legality, any of these cases, call us 800-472-0646. You can email me any of your questions, Adam B, A-D-A-M, B as in Bergman, Adam B at IRAFinancialGroup.com. Thanks again for listening.